Yes, hello, I'm Dr. Adrian Barnett, and I teach land law and children and the law and family law.
Hi, I'm Dr. Pinlin Lau. I teach contract, tort, AI and law ethics and technologies, that kind of stuff.
Hi, I'm Kimberly Spikings. I am a lecturer in law. I'm a practicing solicitor, partner in my own law firm, and I lecture lots of different things. Currently land, but I've done trust, tort, contract, civil justice, bits and pieces.
Okay, my name is Anjuma. I have been the internal mooting officer this year. The year started off with over hundreds of mooting students. I've trained them all to be fantastic mooters. They've all progressed from round to round to round, and they've put in so much effort to get here today. So we've got 8 semi-finalists in front of us today, and they are going to be judged. So let's get it going.
Okay, we're ready to hear counsel.
Do you want
Thank you. Yeah, you can have one bundle. I've got electronic bundles, so that's fine. Thank you very much. This for the respondents, great. Is this one set?
Yeah.
Okay. All right, so.
Before we begin, I would like to ask the court, what would you like to be referred us to? As ladies or lords?
Lords, please.
Lords, thank you. May it please your lordship that I, Julia Machka, shall be appearing as a senior counsel for the appellant. I am here today with my co-counsel, the junior counsel for the appellant, Ms. Rakshan Pirozadeh. May I also introduce the court to the counsels for the respondent, the senior counsel, Mr. Muhammad Jalal Haider, and the junior counsel, Mr. Anik Gupta. Before I begin, could I please ask your lordship to dismiss all formal citations?
Yes, please.
Thank you. Before I present my submissions, would your lordship care for the short summary of the facts of the case at hand?
Would you like
Yeah, yeah.
Thank you. In February 2001, Mr. Allwright has found a property right for developing. He has decided to employ Mr. Black to help with restoration of the property. Mr. Black told Mr. Allwright that the work would cost £1,800, and that included labor and materials. Mr. Allwright accepted Mr. Black's quote on the proviso that the building would be finished by the 5th of April. Unfortunately, due to bad weather and the plaster having to go into hospital for an operation, Mr. Black realized that it would be unlikely that he would finish the job before the 5th of April. He has informed Mr. Allwright that in order to finish the work in time, he would need an additional £5,000 in order to pay his existing workers overtime and employ a new plaster. Although Mr. Allwright could see his profit decreasing, he was more concerned that the flats would not be ready for the tenants to move in, and so he reluctantly agreed. Mr. Black completed the project by the 2nd of April and sent Mr. Allwright a bill for £23,000. Mr. Allwright said that due to his financial difficulties, he could only afford to pay £20,000. Mr. Black agreed to that price as he thought that it is better to inquire a lesser sum than to be left with nothing at all. Mr. Allwright has sent Mr. Black the check for £20,000 and an additional bottle of wine as a thank you. We stand here before you today, your lordship, to appeal the decision of the previous courts on behalf of Mr. Allwright. I shall be linked with the first ground of appeal, it being that at common law, a payment of a lesser sum together with some additional goods, in this case a bottle of wine, is sufficient consideration for the creditors to forego the balance. Could I please offer my first submission to your lordship?
Yes, please.
Thank you. If it may please the court, I would like to begin with my first submission, the Pinnell's case, which can be found in our bundle on page 6 or on the green tab. Before I begin my submissions, would your lordship care for the brief summary of facts of the Pinnell's case?
That won't be necessary, not for Pinnell's case. Please
Thank
proceed.
you, my lord. The Court of Common Pleas with Lord Coke leading has held that part payment of a debt cannot be satisfactory for the whole unless it is provided with some additional goods. In the case at hand, Mr. Allwright has provided the respondent with a lesser sum than that which he owned, as he has encountered financial difficulties and could not provide the full price of £23,000. With the part payment of his debt, he has included a bottle of wine as a thank you. The bottle of wine was not included in the contract agreement between the parties and therefore should be treated as an additional gift. Connecting that to the Pinnell's case, it is crucial to look at the assumption that Lord Coke has presented in his judgment. May I please direct your ladyship to page 6 of our bundle, paragraph 2.
Yeah.
My learned friend, the senior counsel for the respondent, is due to submit the same quote. I would like to submit that regardless of the case being held in 1602, it is still relevant and the principle set in the judgment is still valid. I would like to refer your lordship to page 6, paragraph 2. And it reads, I quote, "For it shall be intended that a horse, hawk, or rope might be more beneficial to the plaintiff than the money, in respect of some circumstances, or otherwise the plaintiff would not have accepted of it in satisfaction." End quote. Mr. Black has voluntarily accepted my client's additional gift of the bottle of wine paired with a lesser sum of money. And according to judgment in the Pinnell's case, that is satisfactory to discharge the debtor of a whole debt.
Can I?
Yeah, please go ahead, Adrian.
You can't really compare, though, can you? What would have been the value in Pinnell's case in the what was it, 19th century, of a horse, a hawk, or a robe, which would be significantly higher than a bottle of wine, and depending on the bottle. But I don't take it to necessarily read from Pinnell's case that any gift, no matter how small, would satisfy the debt. It looks from this case that a lesser sum can be a satisfaction, and they give an example of quite substantial gifts. So can you comment on that?
I'm grateful for your question, my lord. I would like to submit that since Mr. Black has accepted the bottle of wine, he has saw the profit it presented to him, and therefore it constitutes sufficient consideration. In my second submission, I will go over how consideration must be satisfactory, but need not be adequate. Does that answer please the court?
Yes, thank you.
Thank you. Unless my lordship have any further questions, I would like to please move on to my second submission.
Yeah, I have one question. However, the
Yes.
bottle of wine was not solicited by Mr. Alright.
Yes.
It was a gift, right?
Yes.
But it was not solicited as payment or as part payment. So from what I understand, at least, if it has been at the instance of the person who is receiving the payment requesting for a bottle of wine in lieu of £3,000, then I could possibly accept your argument. So what do you have to say?
I'm grateful for your question, my lord. I would like to submit that Mr. Alright has paid the lesser sum of the debt which he owed to Mr. Black with an additional gift, and that gift constitutes sufficient consideration, and therefore it should be accepted that the whole debt is discharged. Does that answer please the court?
Okay, sure.
Thank you, my lord. If it may please the court, I'd like to move on to my second submission, the case of Folks and Beer, which can be found in our bundle on page 9 or on the pink tab. Before I begin, would your lordship care for the brief summary of the facts of Folks and Beer? Thank you. The issue before the House of Lords was concerning consideration. It has been ruled that there was no consideration provided by Dr. Folks, and therefore Ms. Beer's promise was not binding. I would like to submit, contrary to what my learned friend Mr. Heidel is due to submit, that in the case at hand there was consideration in the shape of a bottle of wine. And therefore Mr. Black's promise not to claim any more money from my client should be valid and should stop him from further exploiting my client. Consideration has to move from Mr. Alright, and that would be the bottle of wine, which was accepted by Mr. Black and constituted valid consideration to the lesser sum paid by my client. May I please direct your lordship to paragraph 23, page 17 of our bundle.
Sorry, page what?
Page 17, paragraph 23. Thank you. It was heard by Lord Blackburn. Here, Lord Blackburn discusses a contract law principle that consideration must be sufficient but need not be adequate. And that principle would also apply to the case at hand. Mr. Black has accepted the lesser sum of money, and that was supported by consideration in the shape of the wine bottle. And per Lord Blackbird's judgment, the courts will not inquire into that. Thus, the addition to the lesser sum, no matter how small and of what value, if accepted by the creditor, makes for a sufficient consideration and makes the lesser sum satisfactory for the whole debt. If your Lordship have no further questions, could I please move on to my conclusion?
I've just got a question in relation to one of the overreaching principles that derives from the Pennell's case and that fills into the Fawkes and Bear case is this concept of practical benefit, in the sense that when you accept a sum or a lesser amount of money based on some form of gift or something like that, there is this concept of practical benefit, and there's a lot of discussion there, but I can see in no way whatsoever any submissions that infer whatsoever that a bottle of wine, even accepted, demonstrated as a gift, can form any practical benefit.
Thank you for your question, my lord. I would like to submit that since Mr. Black has accepted it, he must have saw any benefit to that, but I'm afraid that's all I can assist you with that question. Thank you, my lord. To conclude, I submit, based on the Pennell's case, that a payment of a lesser sum paired with some additional goods discharges the debtor of his debt. Additionally, according to Fawkes and Beer, consideration must be sufficient but need not be adequate. Therefore, the bottle of wine, as it was accepted by Mr. Black, constitutes sufficient consideration. Thank you. If my lordship have no further questions, I have presented all my submissions, and unless I can be of any further assistance to the court, I have nothing to add.
Okay. Yeah.
Can I start?
Yes.
If it may please your lordship, I will be presenting the junior round of appeal. If it pleases the court, I would like to begin with my first submission on the grounds that the doctrine of promissory estoppel should operate to prevent the respondent from recovering the rest of the money. Firstly, I submit that when Mr. Allwright told Mr. Black back in April that he was only able to pay the £20,000 and was struggling financially, Mr. Black accepted that. He did not object, nor did he ask for any future demands to be paid later. He accepted the check and the bottle of wine, and through this, his conduct depicts an implied promise, which was clear and unambiguous. And due to Mr. Black's conduct, it is reasonable for Mr. Allwright to rely and assume that they had entered a negotiation, which meant that Mr. Black was satisfied with the sum that he had received, and due to this and the lack of objections and demands for future, this meant that Mr. Black would not enforce his strict legal rights. This is according to the case of Hughes against Metropolitan Railway, on page 33 of our bundle. Would your lordship care for the facts of the case, or rather how it relates to our case?
No, that's fine.
Okay, thank you. The House of Lords, specifically Lord Cairns, ruled that with the initiation of the negotiations, there was an implied promise made by Mr. Hughes not to enforce his strict legal rights with respect to the time limit on the repairs. This depicts the significance of a promise, where on page 36, paragraph 10 of our bundle, it is stated by Lord Cairns, when there is a legal contract, but after the parties enter upon a new course of negotiations with their own consent and by their own acts, this has the effect, which has the effect of leading one of the parties to suppose that the strict legal rights will not be enforced. The party who would otherwise be able to enforce those rights will not be allowed to enforce them where it is inequitable. And Mr. Black's conduct was a clear representation of a promise. Although my learned friends are due to submit on page 3 of their bundle that the agreement between these parties was not modified, on the contrary, I submit that according to the mentioned case, a promise alone can be responsible for preventing a party from enforcing their strict legal rights.
Counsel, I'm just going to stop you here, and I'm going to ask you if there is actually a clear and unambiguous statement that the legal rights will actually not be relied upon, because I don't see it right now.
I'm grateful for your question, my lord, and I submit that Mr. Black's conduct did provide a clear statement in the form of an implied promise, because he did not object, he just accepted the money. He didn't even ask Mr. Allwright to pay him later whenever he's able to. He accepted, and that led Mr. Allwright to believe that the contract was over, and it wasn't mentioned again until months later. Does that satisfy the court?
Is there any authority for saying that simply acquiescing, standing by, not making an active representation of any kind will satisfy a clear and unambiguous assurance? All he simply did was accept the bottle of wine. I'm wondering how far the case law allows you to extrapolate from that.
Yes, thank you for your question, my lord, and I submit that through accepting the bottle of wine and the part payment, there would be, and accepting that, there would be no reason for Mr. Allwright to believe that one day Mr. Black is going to suddenly ask for the rest of his money, because there were no demands even for the future made. Does that satisfy the court? Excuse me, actually, if I may direct you to page 42, paragraph 1 of our bundle. There's a quote by Lord Denning that states the importance of a promise, which is essentially what is happening here. And it says that when a party makes a binding promise, they're not allowed to act inconsistently with it. And since Mr. Black did not object, and now he's objecting, that means he's acting inconsistently with his promise.
But where is the promise in the first place? That's what I'm trying to ask. I don't see the promise that was formed between the parties, whether expressly or impliedly. So, do you see where I'm going with this, right? Yeah.
Yes, thank you for your question, my lord. And I submit that through his actions and Mr. Black's actions and conduct was a representation of an implied promise.
So just a practical question. Do you feel in future that this might actually be dangerous, opening floodgates when we allow claims to be made on this basis, where nothing that is expressly stipulated can be assumed as promises?
Thank you for your question, my lord, and I submit that since implied statements are legally binding in the form of a promise, it is already a precedent that they can be binding and they can work and make the person be bound by their promises.
Okay.
Actually, may I continue on to my second submission?
Sure.
Thank you. Secondly, I submit that since here a promise is implied through negotiations, it is inequitable to allow Mr. Black to act as though this promise never existed. And due to this, promissory estoppel prevents Mr. Black from going back on his promise. Only upon finding out that Mr. Allwright went on vacation did Mr. Black think to ask for the rest of the money, which was months after the contract was over, and after, I reiterate, he accepted the part payment and the bottle of wine without objections. So this is according to the case of Central London Property Limited against High Trees on page 41 of our bundle. Would your lordship care for the facts of the case?
No, actually, I want to ask you a question about the Central High Trees and promissory estoppel generally. The doctrine is generally a suspensory method or approach. It doesn't extinguish rights.
Yes.
So,
thank you for your question, my lord. And in this case, because this isn't a continuous agreement, it is not like every month there was a payment to be made, it is a one-time agreement. So in this case, it can extinguish the rights because it is only a one-time thing and not a continuous agreement.
do you have authority for that? That says that you can extinguish your rights with on a one-time basis?
Yes, that is in the obiter statements of Lord Denning in the case of High Trees.
Okay, time's up. Thank you very much. I'm ready to hear the rest. Adrian, shall we hear the respondents?
Yes, so this is one thing. I haven't got a copy of this. I just literally came straight from teaching. You see, I haven't got a copy of the actual facts of the case.
Oh, I've got it here.
Last time, I just didn't have a chance to get anything together because I was just come straight from teaching. Okay, thanks.
Go ahead. Yes, we're ready to hear the respondents.
Good afternoon, Your Lordship. Your Lordship, if it pleases the court, may I begin with my first submission?
Yes, please do.
Your Lordship, my first submission is related to and supported by the case of Penny and Cole, also known as Penal's Case 1601, which can be seen on my bundle, page 6.
Yep.
Your Lordship, my first submission is that the payment of a lesser amount for a greater sum cannot be considered a valid consideration. And as also said by Lord Edward Scott in that case, which can be seen that in my bundle para 2 of page 6, it is stated that a lesser sum can never be considered to be a satisfaction for a greater sum unless it is a gift such as horse, hawk or a robe. And it must be intended that the horse, hawk or a robe is beneficial to the claimant that is being gifted that thing. And as it relates to our case, my client has been gifted a bottle of wine has not has been paid by the £3,000 which my learned friend's client owes to him. Due to that, it cannot be sent it is a beneficial gift. A wine cannot be used in anything. And the case we are looking that I'm supporting my submission with pen and coal, it is in 1601, and in that time the gifts such as horse and robe, was the main things, and as the horses were used for transportation. And as you can see, the measurement for a beneficial gift was so high that if we relate to our case, the wine is nothing and it cannot be considered a valid satisfaction, and my client never intended that it would be beneficial for us. For that, I would like to submit that it cannot be considered a valid consideration.
Are you disputing the value of the wine, counsel?
Thank you for your question, my lord, and I would like to submit that I'm not disputing the value of the wine, but I'm submitting that as the principle established in this case, unless it is of benefit, it can never be considered to be satisfaction and a valid consideration unless supported by that it is intended to be beneficial to the claimant. And in this case, it is not beneficial to my client, for which it cannot be considered to be a valid consideration.
But your client has not given any indication that he wants a refund of the monies at that particular instance of time.
Thank you for your question, my lord. I would like to submit that my client, even though he never submitted that he wanted to get a refund or something like that, but my client didn't hope that his 3,000 pounds were not going to be paid, as he hoped that were the money owed and he will be paid back. He only accepted due to the reason that it was a gift with a gesture, because my client did completed the work before the due date was required, which was 5th April. My client did completed the work on 2nd of April.
Okay. What about the fact that your client was actually paid more money to complete the work?
Thank you for your question, my lord. I would like to submit that, as you can see the fact, which states that my client's plasterman was injured, for which he needed to replace that. He needed to complete the work before the due date to able to save my learned friend's clients, as he wanted to rent out that place, for which we can say that he needed to overpay the staff. That's why it satisfies that the work needed to be paid more. He needed to overpay his workers in order to fulfill the requirements of the contract.
Okay.
If it pleases you.
Yeah, okay.
If you have no further question relating to my first submission, your lordship, may I begin with my second submission?
Yes.
Your lordship, my second submission is related and supported by the case of Folks and Beer, which can be seen on page 9 of my bundle. And your lordship,
page 9. Yep, that's right, we've got it.
your lordship, as the amount was owed by my learned friend's clients, which was of £3,000, and it was never paid back, for which it needed to be paid with debt, as supported in the case of Folks and Beer, 1884. Would my lordship like to know the facts of the cases?
No, that's not necessary.
Your lordship, if you will move to para 58 of my bundle, page 27.
Yes.
You will be able to see that it is explicitly mentioned that in a judgment order of debt, it is required to pay the interest of 4% at every cost, for which the money paid to my client was £20,000 rather than the agreed amount of £23,000, and the remaining amount of £3,000 should be paid with interest.
Sorry, just explain that to me again. On what grounds are you claiming interest?
Thank you
Explain
for
that
your
to me
question.
again.
Thank you for your question, my lord. I would like to submit that as stated in the case of Folks and Deer, 1884, it is explicitly mentioned that in a judgment of debt, it is considered to pay the amount of 4% interest if the debt is never paid. And even in the case of Folks and Deer, the debt of £2,000 was already paid. And
Okay.
still,
No,
after that,
I don't that's not correct. I think you need to look at the statutory regime of the County Courts Act,
Yeah.
section 69,
Yeah.
which states that there's a statutory level of interest applicable in relation to debt claims. That can be inflated if there's a certain a subsection within a contract or an express agreement to the alternative, but that's not correct.
thank you for your question, my lord. I would like to submit that in the case of Folks and Deer, after the claimant bring the first submission.
Yeah, we understand, Council, but Folks and Deer was in 1884. And from then on, what my learned friend is trying to say is that the regime for the governing of statutory interest is different now. So instead of relying on Folks and Beer, we're asking you what other statutes you might rely on for claiming interest on debt.
Thank you for your question, my lord. I would like to submit that I have no further case in my skeleton relating to this. However, I would like to consider the case my learned friend mentioned, Folks and Deer, in which para 22 of page 17, even though it is not mentioned the interest, but my learned friend mentioned in their submissions that as our client did accept it and it is not considered to be, the gift of wine is considered to be a valid consideration. And they also submitted the penance case which they supported that was relevant to their scenario. I would like to submit, as you can see in that case, and para 22, it is explicitly mentioning the case of Pinnells and Cole, in which in the last 3 lines of it, it states that if the amount to be paid in York and the claimant asks the amount needs to be paid in Westminster, it can be paid less due to the reason that it will cover the cost of traveling. However, in our case, there was no agreement and my client never agreed to get the less money, and still their client just paid the gift and did not pay the amount owed, for which it can be considered that it is a valid not a valid consideration, and for which they owe the debt and they need to pay. However, I do not have any supporting point with the question relating to the interest. I just have this case and I hope that I can rely on this to the reason 4% of interest rate.
What would you say to my question that it would be completely unconscionable for your client to regale on the position? So of the acceptance of this bottle of wine, what would you say to my suggestion that it would be unconscionable for him to now suggest that the remaining debt is owed?
Thank you for your question, my lord. I would like to submit that my client, it cannot be considered unconscionable, as my client only thought and accepted the gift due to the reason that my learned friend's client was considered to be having no money and he was in financial difficulties. And as seen, he went on a 3 weeks holiday to Florida with his whole family, which can be considered that he had money and he had the supporting financial capabilities.
So if you're suggesting that your client accepted the lesser sum because there was a practical benefit of fear of the other party not paying, then is that not counterintuitive to your argument?
Thank you for your question, my lord. I would like to submit that it is not countering the argument. However, it is just stating the fact that at that time my client accepted only that amount due to the reason at that time he thought that the claimant, the appellant didn't have the money, but later as he found out, my client never released him of his debt or anything, but later when he found out that he was on a holiday, my client came for the money that Mr. Allen owed to him.
Your client waited 2 months before so you found out in May, waited 2 months before he wanted to regale on the satisfaction of the debt.
Thank you for your question, my lord. I would like to submit that as my client was assisting with the legal submissions and like to have legal advice how he can come and assist with. So that's why it took time. Otherwise, we would have come earlier to relate to this case. And if it pleases you, can I go on?
It's okay, thank you very much.
Thank you.
Anything else? Okay, please proceed.
Good afternoon. May it please your lordship, I appear for the junior respondent on behalf of my client, Brian Black. My two submissions that I wish to bring forth for this case will establish how the doctrine of promissory estoppel should not operate due to the fact that Mr. Allwright is bound by the original contract in which £23,000 is owed to my client for the completion of restoration works for Mr. Allwright. I will also submit how the appellant's claims of financial difficulty were insufficient, making it equitable for my client to have retrieved the outstanding balance that the appellant owed. If it pleases your lordship, may I begin my first submission? It is my first submission that Mr. Allwright had an agreement with my client, Mr. Black, who is a builder. The agreement consisted of the restoration of Mr. Allwright's property for the sum of £18,000, which increased to £23,000 due to adverse weather conditions and employee injuries. This agreement was agreed by both parties, and I would submit that the appellant did not pay back the agreed amount of £23,000 and is therefore liable to settle the outstanding debt. Promissory estoppel would therefore not have applied in this case, since there was no pre-existing contract or legal obligation which was then modified. I'd like to direct your lordship to the case of Combe and Combe, which can be found on page 63 of our bundle.
Sorry, counsel, what do you mean there is no existing legal relationship between the parties or pre-existing contract?
There was existing legal relations between the parties, but however, I'm humbly submitting that there was no modification of the contract further on. Would your lordship care for the facts of the case? However, I would submit that the legal principle is more relevant in this case.
Yeah, legal principles, please.
On page 68, your ladyship shall find that the court had to establish whether the wife had given consideration in return for the husband's promise, and if the wife could claim the sum of money that was promised previously. On page 71, it was held that the wife sought to use promissory estoppel as a sword.
Can you just let us get there?
Sorry, I apologize.
Okay, go on.
The wife sought to use promissory estoppel as a sword and not a shield, and that no consideration was given by the wife. Therefore, the wife could have a claim for the money. My appellants have used the case of Central London Property and High Trees Limited, which can be found on page 41 of their bundle. In this case, consideration could be established due to the fact that lower payments were accepted because they were in World War II. Therefore, lower payments could be accepted, and this established sufficient consideration. However, there is no such consideration in the case in hand, as the outstanding balance of £23,000 owed to my client still stood because the existing contract was not modified in any way. The appellant did not counteroffer a sum of £20,000, rather he partially paid the full amount due to supposed financial difficulties. This is not sufficient consideration for a modification of the contract, since it does not reduce the value of the work that was undertaken by my client. In this way, promissory estoppel cannot apply, as the original agreement between Mr. Allwright and Mr. Black still stood. If your lordship has no further questions, may I proceed to my second submission?
Just give us a minute, please.
So let me just get this straight. You're suggesting that promissory estoppel can't apply in a situation where there is there's an outstanding contractual relationship. So you're suggesting that the original contract stands, and therefore, because there was no consideration in relation to the acceptance of an underpayment, and therefore promissory estoppel can't apply. My understanding is that they're two completely separate arguments.
I'm grateful for your question, my lord, and just to clarify, there was pre-existing legal relations between the parties. However, this was not modified in the later agreement between...
Right, that's point one. So how does promissory estoppel link to point one?
Promissory estoppel cannot be applied in this case, since there was no modification of the contract. Does this answer please the court? Okay.
I'm not sure that promissory estoppel requires there to be a modification.
Well, you're saying that there was no assurance given, no representation given by Mr. Black that he would accept
Yes,
the bottle of wine?
that is what I am submitting. That's correct. May I proceed to my second submission? It is my second submission that despite being unable to pay my client the full cost of the restoration, Mr. Allwright was still somehow able to take his family on a 3-week holiday to Florida. And a holiday of this magnitude and of this time period would suggest that the appellant does not in fact have any financial difficulty.
When was the holiday booked?
The holiday,
When did he book his holiday?
it is unclear
Right.
when
Okay.
he booked the holiday. However, I would also submit that whilst on holiday, the appellant would still have to spend a considerable amount of money on the holiday, which does not suggest to me that he has any financial difficulty. Therefore, he is more than capable of paying the remaining £3,000 to my client, and I would submit that if Mr. Allwright can take his family on an expensive holiday, he can prioritise clearing his outstanding debts, especially owed to my client, who along with his staff had to work overtime in very harsh weather conditions in order to complete his restoration in a timely manner. Promissory estoppel would therefore not apply, since it would indeed be equitable for my client to have retrieved the full £23,000 that was agreed. I'd like to direct your late lordship...
Let me just ask you something, though. Isn't this holiday in Florida a bit of a red herring? I mean, your client thought that Mr. Allwright was in financial straits and decided to settle for a lesser sum. I mean, that was a decision he made. It looks like he's now trying to revive.
I'm grateful for your question, my lord, and I would submit that he did not decide to settle for a lesser sum. He simply accepted the £20,000 as part of the original, as a part of the original.
Doesn't say that in the
agreement.
facts, though. What it says in the facts is that, hang on.
Right, I thought he better
Yeah,
accept
he-
20,000.
Brian thought he better accept the 20,000 in case he ended up with nothing at all. Doesn't that imply that he's thinking, well, I'll take something that's better than nothing?
Yeah.
Thank you for your question, my lord, and I would humbly submit that there is sufficient consideration for my client to claim the full agreement of the £23,000. May I please conclude my submissions? To conclude, Mr. Allwright had not paid my client the agreed amount of £23,000, which he was legally obliged to pay, since there was no true agreement to accept a lesser sum, and the original agreement still stands. The appellant also misled my client as to his financial position, and it is therefore equitable for my client to have retrieved the remaining balance that was owed. For these reasons, the doctrine of promissory estoppel cannot apply, and I would humbly invite your lordship to dismiss the appeal. I'm very grateful for your lordship in welcoming my submissions, and unless I can be of any further assistance to the court, on behalf of Brian Black, those are my submissions for the junior respondent, and I have nothing further to add.
Thank you. Yeah, we're done.
Well done. Okay, switch.
That was, you did so amazing. Me? You did so well. I was really impressed.
No, legit.
Do you know, I'm going to say something about this. This drives me crazy when they produce these.
No, I know.
I mean, why is it not in a ring binder?
I know. Okay.
Thank you.
Yes.
Thank you. I mean, and also, there's
Yes.
I need to show you something. What's this about? There's something. There's a lesser sum with just a lot. I mean, what the heck?
Okay, so we've got. Okay, so these were the earlier ones. This is the appellants.
The current appellant.
The current appellants, not this one. So this is done.
That's done. Shall I put that in?
And this is the respondents.
Yeah.
And I've got the...
So, hang on. Let me just
Appellant.
get my...
To share this.
Okay.
And this is respondent.
Oh my God. What point is this in?
Okay, so this is respondent.
Yeah.
Oh, so too small.
It's way too small.
Good luck, guys.
Right.
This is good.
Right, please begin.
Well, good afternoon, Your Lordships. I'm Vanessa Warner, and I'm going to be the senior counsel for the appellant. I would like to introduce my junior counsel for the appellant, Ms. Florence Goodale.
alongside my learned friends, the senior counsel for the respondent, Ms. Winnie Mady, alongside the junior counsel for the respondent, Ms. Keelan Montag. Would your lordships like the facts of the case at hand?
No, that's not necessary.
Right. If it pleases your lordships, I would therefore like to make my first submission. I submit that payment of a lesser sum included with an additional gift, which in this case was a bottle of wine, is sufficient consideration for the rest of the additional payment demanded by the respondent to be discharged. I will direct your lordships to page 6, paragraphs 1 and 2 of our bundle. Would your lordships care for the facts of the Pennell's case of 1602?
No.
In that case, my lordships, I submit that in this case, Lord Coke held that payment of a lesser sum on the day cannot be satisfaction for the whole, but the gift of a horse, hawk, or robe in satisfaction is good, for it shall be intended that the horse, hawk, or robe might be more beneficial to the plaintiff than the money, and that this, alongside an additional gift, ought to be pleaded in full satisfaction.
How much was the debt owed in the Pennell's case?
The debt was £8 and 10 pence, but the court had held in favour of the defendant in that case, as he had paid the sum of £5 and 2 pence 1 month and 6 days earlier.
And do we know the equivocal value of a horse, hawk, robe, etc. in satisfaction at the time? By way of comparison.
I'm grateful for your question, my lord. I would submit that with inflation values, it's impossible for us to know the exact values of those items today. However, I would say more broadly, Lord Coke held that broadly a gift constitutes sufficient consideration alongside partial payment.
Sorry, can we just keep going with that? He didn't just say a gift. I mean, a gift could have been a paperclip. He said payment, the gift of a horse, hawk, robe, etc. So he's implying a substantial gift. But in this case, there's no suggestion at all from the facts that the bottle of wine was given as a gift in part satisfaction of the debt. He was paid Mr. Black was paid £20,000, and the bottle of wine looked like a thank you for accepting a lesser sum, not thank you for paying 20,000. Here's something on top to make up for the difference. That's what the facts look like.
I'm grateful for your question, my lord. I would submit that in our case, the respondent had accepted the appellant's partial payment alongside the gift and did not immediately bring action against the appellant until 3 months later. Therefore, I would submit to the court that he had accepted the partial payment alongside a gift as full satisfaction for the whole, and that the gift was included alongside as sufficient consideration.
I'd like to ask you, counsel, about whether there has been, in your opinion, a new element introduced into this arrangement right now, because according to Pennell's case, right, part payment is not sufficient consideration unless there is some form of new elements that have been introduced into the contract. So what is the new element in this instance here?
I would submit that the new element was the bottle of wine, and that it was accepted by the promisee as consideration, as he did not bring immediate action, and he had accepted the offer as stated in the facts of this case. And therefore, he had accepted it as sufficient consideration and paid in full satisfaction for the whole.
Okay, thank you so much for the answer. But also, I agree with that statement, but the additional qualification is that the sufficiency of the new element would be subject to it being the request of the promisor, not the promisee.
I would submit that because the promisee did accept it and did not reject it, that he therefore accepted it and considered it sufficient consideration, which goes into my second submission, my lord.
Okay.
I would therefore submit to your lordships that the appellant in this case included a bottle of wine alongside his partial payment, and that consideration is sufficient. And unless you have any further questions on my first submission, I would like to move on to my second submission, my lordships. I submit that contrary to the senior counsel to the respondent's bundle, on page 6, paragraphs 5 and 6 of her bundle, consideration was conveyed in satisfaction of the monetary loss by the respondent. I submit that on the senior counsel for the respondent's bundle on page 6, paragraph 6, Lord Coke held that the gift of a horse, hawk, or robe might be more beneficial, otherwise the plaintiff would not have accepted it in satisfaction. And in our case, the respondent, Brian, initially accepted the £20,000 alongside the bottle of wine as paid in full satisfaction. And therefore, I submit to your ladyships that it has therefore been paid in full satisfaction if it has been accepted in full satisfaction. I submit to your lordships that the gift of the bottle of wine was something of an additional benefit to make up for the lesser monetary payment that was made, and that this was established in the case of Chappell and Nesty of 1960, where I will direct your lordships to page 23, paragraph 69 of our bundle. Would your lordships like the facts of this case?
No, that's fine.
I would like to submit to your lordships that Lord Somerville held that a contracting party can stipulate for what consideration he chooses, and that a peppercorn does not cease to be good consideration if the promisee does not like pepper and will throw away the corn.
Sorry, but I mean, in our case, we can't possibly say that Mr. Black accepted the bottle of wine. I mean, he was given it. And the highest you can put it is that he didn't send it back. He was just given it as a gift. That's not quite the same as choosing or stipulating the bottle of wine as part of consideration, is it?
I would submit to your lordship that as he had accepted it alongside the partial payment, that therefore he had considered it sufficient consideration, and that being that he accepted it and did not tell the appellant in our case that he would not be accepting partial payment, that therefore he has stipulated that this consideration is sufficient for him alongside a partial payment. And that I would like to submit to your lordships that consideration as per the Chappell and Nesty case of 1960 does not have to have economic value at all. Consideration can be considered sufficient even if it has little to no economic value. Your lordships, I would like to submit that this case of Chappell and Nesty of 1960 has established the precedent that consideration need not have economic value. And I would submit to your lordships that the promisee not need even to have to like the bottle of wine for the consideration to be considered sufficient and paid to the promisee, even if the respondent in this case did not even drink the bottle of wine. The consideration would still be considered sufficient. Your lordships, I would like to submit that the additional consideration of the bottle of wine, it need not have equal economic value to the amount of £3,000. And I would like to submit that while we may never know the exact value of this bottle of wine that was given in full satisfaction alongside the partial payment, I would like to submit that the highest amount of bottled wines ever sold for has been in the amount of £410,000 at a New York State auction, which could be even more than what the respondent is suing the appellant on behalf of. And therefore, I would submit to your lordships that while it need not have specific economic value, it certainly constitutes sufficient consideration paid in full satisfaction.
You would have thought if Mr. Allwright could afford to buy a bottle of wine like that, that amount he could pay Mr. Black, couldn't he?
I just want to recap the point that you're trying to make in relation to consideration. So you're suggesting that, so the Pinnell's case is quite clear in relation to the acceptance of a lesser sum in part payment of debt, so long as there is a practical benefit. I haven't necessarily heard you discuss this point of practical benefit, which I consider to be key. What you seem to be suggesting is that this wine is a substitute consideration. It's substitute consideration, thereby varying the contractual agreement. Is that not a completely separate point to the point that you're trying to make in the pursuant to the Pinnell's case?
I would submit that this consideration given by the appellant to the respondent does constitute a practical benefit, as it can be drunk and enjoyed by the respondent in this case. And I would like to submit that, I know it's not in my bundle, but on contrary with William and Rafi, that it was the respondent's own idea to include, to discharge his contractual duties unless the appellant had paid additional sum, where that was not the case in the case of the practical benefit clause being established in Williams and Rafi, even though it's not in my bundle. Regardless of your lordships, I would like to submit that regardless of the bottle's monetary value, I submit that as per the precedent set out in Chappell and Nesty of 1960, an additional gift paid to the respondent to this case need not have any specific economic value to be considered efficient consideration paid in full satisfaction alongside the partial payment. And unless your lordships have any further questions alongside my second submission, I would ask that you find in the appellant's favor and that you overrule the Court of Appeals decision and that you rule in favor of the appellant.
Thank you. Yes.
May it please the Court that I, Florence Goodale, am appearing as junior counsel for the appellant in this matter. If it may please your Lordship, I wish to begin with my first submission on the grounds that the doctrine of promissory estoppel does apply in this case and prevents the respondent from recovering any additional sum of money or interest from the appellant. If it may please the Court, may I begin my first submission. I submit to your Lordship that all of the requirements necessary for the doctrine of promissory estoppel to apply are present in this case. I would like to direct the Court's attention to the case of Central London Property Trust and High Trees, located on page 33 of our bundle.
Okay.
It is established in this case that a clear and unambiguous promise is necessary in order for the doctrine of promissory estoppel to apply, with Lord Denning stating on paragraph 8 of the judgment that a promise to accept a smaller sum in discharge of a larger sum is binding, notwithstanding the absence of consideration. Applying this principle to the case at hand, it is our submission that acceptance of the lesser sum by the respondent is binding upon him and prevents him from recovering any additional sum of money from the appellant. Thus, it can be established that the doctrine of promissory estoppel must apply within this case.
So, Counsel, are you saying that accepting a bottle of wine equals a promise that must be relied upon?
I'm grateful for your question, my lord. I would submit that the acceptance comes in not protesting against the £20,000 which was paid to him. That is the express promise, an implied promise, to accept the sum of money and the bottle of wine as further consideration. Does that answer satisfy the Court?
Okay.
If your Lordship have no further questions, may I proceed to my second submission?
Yes.
In the case at hand, it is our submission that all elements required for the doctrine of promissory estoppel to apply have been met. May I direct your Lordship's attention to the case of Combe and Combe, located on page 25 of the bundle. In which it is established that an existing legal relationship must exist between the parties in order for the doctrine of promissory estoppel to apply. This principle is clearly expressed by Lord Denning in paragraph 4 of the judgment, in which it is stated that a promisor must accept their legal relations subject to the qualification which he himself has introduced, even though it is not supported in point of law by any consideration, but only his own word. My learned friend, the junior counsel for the respondent, is due to submit that a claim for promissory estoppel will not be successful as the promise was not freely given, relying on the authority of D&C Builders and Rees. It is my submission that the facts of that case are distinguishable from the case before us, and if I could direct the Court's attention to page 44 of my learned friend's bundle, paragraph 42, it is stated by Lord Denning in this case that
Page number?
Page 44, paragraph 42.
Yes.
When there has been a true accord under which the creditor voluntarily agrees to accept a lesser sum in satisfaction, and the debtor acts upon that accord by paying the lesser sum, and creditor accepts it, then it is inequitable for the creditor afterwards to insist on the balance. Furthermore, the facts of the case establish that there was a reliance on the promise to accept a lesser sum. Thus, it must be concluded that reliance on this promise is binding upon the respondent, and the doctrine of promissory estoppel applies in this case to prevent the recovery of any additional sum of money or interest.
But hang on,
Yes.
there's one sentence that you left out there.
But he's not bound unless there has been truly an accord between them.
Now,
Which is,
that's what you need to kind of get that hurdle off the ground.
I'm grateful for your question, my lady. My lord, apologies. I would submit that there has been a true accord between these two parties, that the acceptance of the lesser sum is binding upon the respondent, that the respondent decided to settle on that amount, and so therefore the doctrine of promissory estoppel must apply to prevent the recovery of any additional sum of money. Does that answer satisfy the court?
Yes, but also the doctrine of promissory estoppel is a suspensory doctrine, similar to what happened in the Central High Trees case, right?
Yes.
Which means that the payment for full rental would have resumed after the war. So, since the position has improved, do you not think that the balance of the money should be paid then?
I'm grateful for your question, my lady. I would submit that the contract between these two parties has ended, that the acceptance of the sum of £20,000 is binding and ends the contract between the two parties. And if I could direct your lordship to page 25 of the bundle, paragraph 3, it is stated in the Combe case that a creditor is not allowed to enforce a debt which he has deliberately agreed to waive if the debtor has changed his position in reliance on that waiver. So,
Has there been any reliance?
I would submit that there has been reliance on the promise.
Also, do you realize that a contract may come to an end or completion at a certain period of time, but there is the statute of limitations does provide that you have this extended period of time to bring actions for breach, if that's necessary.
I'm grateful for your question, my lord. I would submit that the acceptance by the respondent of £20,000 is binding upon him, and it is final. And if I could move to conclude. To conclude, I would ask the court to find in favour of the appellant's submissions, being that payment of a lesser sum and gift can constitute sufficient consideration to discharge the debt, and that the doctrine of promissory estoppel applies in this case and prevents the recovery of any additional sum of money. We therefore ask the court to find in favour of the appellants and allow the appeal. Thank you.
Thank you. Yes, please.
If it pleases the court, as a senior counsel on this matter, I will be representing the respondent, Brian Black, submitting that he is not entitled to be bound by his promise to forego the balance of £3,000 on the basis of absent and necessary consideration on the part of Mr. Alan Allwright. May I present to the court my first submission?
Yeah.
I submit that Judge Deed did not, in fact, err in the law in applying the penal's case that payment of a lesser sum in satisfaction will not be viewed as good consideration. Mr. Alan Allwright cannot be exempted from this ruling on the basis that the wine bottle was merely presented as a gift for the acceptance of the lesser sum and the work that had actually already been completed. And thus, this does not constitute the necessary consideration that must be present in order to render the promise to forego the balance enforceable. If I can direct the court's attention to paragraph 5 to 6, page 6 of my bundle.
So page 6.
Page 6 of my bundle. Where the court highlights that a horse or hawk or rope might be considered a payment of a lesser sum in satisfaction of the promise will be considered satisfiable. Will not be considered satisfiable, but a horse or all rope might be considered so, as long as it is in satisfaction of that lesser sum. I submit, therefore, that the wine bottle cannot be viewed as consideration, since it was a mere thank you gift, and thus it should not be stated or concluded that this was to be made in compensation for the lesser sum that was suffered as a loss for Brian Black's decision to forego the balance.
So you've just said it, client. Your client has made the decision to forego the balance.
That's correct.
So the facts also tell us that he has decided to accept the 20,000 anyway, because he was afraid that he would get nothing at all.
I'm grateful for your question. I'm grateful for your question, my lord. However, I must highlight that Mr. Brian Black is entitled to renege on his promise on the basis of the Pinnell's case. And the fact that the condition upon which he would be prevented from going back on his promise would only be satisfied had the necessary consideration actually be applied. I submit, though, that he was influenced rather by the risk of losing out of payment for work that he had actually already completed, and thus it cannot be said that the wine bottle added anything material in his decision or his latter agreement.
Yeah, but Chappell and Nestle tells us consideration does not have to be sufficient. It just only needs to be adequate. So the value of that isn't in question here. So
I'm grateful for your question, my lord, and I will address the value of the whatever additional good is made in compensation for a lesser sum in my next submission.
okay, right.
Do the courts wish? Sorry, does your lordship wish to ask any further questions, or may I proceed to my second submission?
Yes, please proceed. Yeah.
Thank you. I submit that it is imperative that any additional good that is offered to compensate for the lesser sum is actually something of value to the creditor. This is in accordance with the case of Folks and Beard, the ruling under this jurisdiction. Do the courts wish to hear the facts of the case?
No.
Instead, I contend that the legal principle is of relevance, which states that whatever is given in satisfaction must construe some benefits, actual or contingent of a kind which might be considered in law valuable. So I submit that by merely presenting the wine gift, it only represented an act of courtesy, arguably, for the lesser sum of payment which was subsequently accepted by Mr. Brian Black. And thus it cannot be said that this was actually something of value, adding and compensating for the loss that was borne by his agreement. If I can direct your court's attention to page 23 of my learned friend's bundle, under paragraph 69, where it is emphasized by Lord Justice Jenkins that
23. Page 23.
Page 23.
Paragraph
69? Or paragraph 69?
Of a bundle.
Of their bundle.
Oh,
of my learned
okay.
friend's bundle.
All right.
That's what I'm looking at.
Oh.
Oh, no. Oh. You're in sorry.
The appellant.
My bad. What page did you say?
Okay, got yes.
23, you said.
Yeah.
Thank you very much. In the case of Chappell and Nestle, it was decided and clarified by Lord Justice Jenkins that a peppercorn does not cease to be good consideration if it is established that the promisor does not like the pepper and will throw away the corn. This was considered because the economic value of the wrapper was insufficient. It was considered insufficient. However, it was ruled by his lordship that the fact that the wrapper actually added some type of value because it would help the defendant the claimant to reach his hit recordings showed that it could be of value in the circumstances at hand. And thus, I submit that while economic value of the additional good is insignificant, what must be looked at is the potential value that it adds in light of the circumstances.
I'm struggling to see how this particular case and this paragraph helps you.
This paragraph helps me. It's in direct response to my lord's question of why I have used my argument, since the value of the wrapper was not seen as substantial. However, by contrast, I submit that although the wrapper was not seen to possess any economic value, the fact that it added a benefit that was material in the circumstance highlights that it must still add some kind of benefit to.
Can I just ask a question? Yes. In relation, so I think you're trying to assess this benefit, but when the court considers benefit, in whose eyes do they consider it in? Is it as an objective assessment? Is it a subjective assessment? Mm-hmm. Where does the burden lie
The burden lies on the creditor. The creditor has and the promisor. The promisor must actually consider whatever is given as an additional good, a compensation for that lesser payment, to be something that he views as something of value. And this is clarified.
And when does he have to make that decision then? At the time that he accepts it, or in hindsight months later, after the fact?
The time at which he considers this is immaterial, because according to the Pinel's case, the creditor is allowed to forego his promise, to forego a balance and go back on his promise. If I can direct the court's attention.
Well, I doubt that it says that you're allowed to forego your promise. It just says that part
there must
payment.
be conditions.
Yeah,
there are specific considerations, and specifically, I must draw your attention to the nature of the consideration. In the case of Folks and Beer, it was highlighted that it ought to have been pleaded that part payments or whatever is given in compensation was actually pleaded by the promisor. And I contend that since it was not pleaded that this wine bottle be added on to the lesser payments, this cannot be considered sufficient consideration on these grounds.
yeah, you can wrap up.
If the courts if my lordship have no further questions, I conclude that Brian Black must not be bound by his acceptance of the lesser payment on the basis that the necessary consideration was not provided by Mr. Allen Allwright. In addition to this, it was not seen as something of value. The junior counsel on this matter will argue that he cannot alternatively rely on the doctrine of promissory estoppel in the absence of the necessary consideration, as the conditions have not been fully satisfied to allow that to occur. And thus, I hope that your lordship will be receptive towards my argument in concluding that he should not be bound by his promise.
Thank you.
Thank you very much.
Yes.
Good afternoon, your lordships. May I please submit my first submission on the second ground of response, which is that promissory estoppel cannot operate for the case at hand. I submit that it will not be inequitable for Brian to renege on his promise. I note that my learned friends in their bundle submit using the authority of Central London Property Trust and High Trees House on page 33 of their bundle. They state that for the doctrine of promissory estoppel to apply, there needs to be a clear and unambiguous promise between the parties, and therefore the £3,000 is not payable. However, my learned friends fail to consider that there are other conditions that need to be satisfied, namely that it needs to be inequitable for the promisor to go back on the promise for this to not be the case. Similar to my learned friends, may I draw the court's attention to Central London Property Trust and High Trees House on page 36, paragraph 26 of my bundle, which is the yellow tab.
Yellow tab. Yeah.
Would your lordships care for the facts of the case, although I submit that the principle is more relevant?
Yeah.
Lord Denning states, for the validity of a promise to be recognised, it is binding notwithstanding consideration, and if the fusion of law and equity leads to that result. Therefore, he highlights that where the law of equity allows for the promisor to go back on the promise, then this can be done, because there would be no reason for this to not take place. I submit that my learned friends state that all of the conditions are satisfied, but I submit that they have completely ignored that it is not satisfied, because they have ignored that the fact that it needs to be inequitable for the money to not be recovered. And the facts that they have ignored based on this is, one, Alan's concern since having to pay for extra for the project was always that his profits would dwindle. and therefore he needed to get his tenant moved into the house, moved into the property as soon as possible. And number two, as a result of this worry that he had, it led Alan to conceal the true means as to why he could not pay the extra £3,000. And this is evident because he went on holiday. He went on a family holiday, which means that he did have the means of paying. So it will not be inequitable to go back on that promise.
Well, we don't know when he got the money for the family holiday. He could have had a windfall after the debt had been, as far as he was concerned, satisfied.
I'm grateful for your question, my lord. However, I submit that although we're not sure when he paid for that holiday, there is still charges that would incur while on that holiday. There's extra costs that would happen, and therefore, if he didn't have if he had insufficient funds to pay Brian, then he would have insufficient funds to be able to pay for things while he was on the holiday. Does that satisfy my lord?
Sort of.
But I'm going to bring you back to page 36, the particular statement that you made just now, right? Sorry, I'm looking at it again here. I'm sorry, how are you relying on this particular paragraph, paragraph 26, right? How are you relying on this to support your client's claim?
I'm grateful for your question, my lord. I'm relying on this because, as Lord Denning states, for the money to not be able to be recovered, it has to be inequitable to go back on that promise. And it's not inequitable to go back on that promise because Alan did have the means to pay for it, and he concealed the fact that he did have these means.
Okay, I'm surprised because it seems to suggest to me here that a promise to accept a smaller sum in discharge of a larger sum, if acted upon, which we're asserting that there is binding, notwithstanding the absence of consideration. And you're saying that we need consideration. We don't, according to Lord Denning's statement over here. And if the fusion of law and equity leads to that result, so much the better. So I think this might actually be quite detrimental to your case, no?
I'm grateful for your question, my lord. However, this is not the case. The fact is that I'm highlighting the fact that he says if the fusion of law and equity allows, and therefore, if it is not inequitable to go back on that promise, then there is no reason that they should not be able to. If I could please direct the court, if you could. If I could please direct the court to page 37, paragraph 30 of my bundle.
Mm-hmm.
Yeah. Lord Denning states that the conditions prevailing when the reduction was made had completely passed away. And it is the same for this case. In that case, the war was in which the reduction was made. In this case, the condition in which the reduction was made was the fact that he was unable to pay because he had insufficient funds, but he did have sufficient funds. If your lordships have no more questions, may I please go on to my second submission?
Yeah. Just wrap it up as quickly as possible, please. Yeah.
Yes, my lord. So yet again, I submit that my learned friends failed to consider the fact that, leading on from my first submission, equitability is measured by the fact that the choice is given freely. My learned friend stated that the choice was given freely, but however, may I please direct you to page 45, paragraph 55 of my bundle to the case of DNC Builders and Rees. Would your lordships care for the facts of the case?
No.
Lord Dankworth states that the plaintiff did not want to accept the reduced rate, but was desperate to get some money, and the defendants misled the promisor as to having insufficient funds. This is the same for this case. Number one, Brian did not want to accept the reduced rate, but he had a fear of not being paid. And number two, the defendants misled Brian as to having the insufficient funds, again, as I stated in my first submission, because he did have sufficient funds, and that is evident because he was able to afford to go on holiday.
Okay, thank you very much. Can you... Yeah.
That concludes my second submission, my lord. And in conclusion, promissory estoppel cannot be applied since the conditions were not satisfied. Namely, that it would not be inequitable to go back on the promise, and it would not be inequitable because he had misled Brian, and therefore the choice to accept the promise to begin with was not free. If that is all, I ask that the court rules in favour of dismissing the appellant's claim.
Thank you.
Okay, well done.
Thank you. Okay, so the first person who's going through to the finals of our internal mooting competition is... Do we not have music?
Should we do drum roll?
Yes, Julia.
Do you want to stand up? I think you should stand up.
Sorry? Yeah.
Okay, next.
The next person going through is Vanessa. Number third. Good Lord, what happened to my English? Number 3, sorry. Third person going through is Florence. And the fourth and final person who's made it to the finals is Anik. Thank you very much, all of you. Congratulations. And to all who did not make it as well, I completely echo what Dr. Adrian Barnett has said. You all were fantastic. You made this really, really, really hard for us. But congratulations, and thank you for giving us the pleasure to judge you today.